All right, state call your initials, please.
Sergeant Barbarato, please.
Sergeant Barbarato.
Stand in the circle, please raise your right hand.
You swear or affirm to the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir.
Sergeant Barbarato, would you state your full name, please, and spell all of it?
Sure. First name is Anthony, Anthhomy. Last name is Barbarato, Barbarotto.
And you're a sergeant
Sergeant,
with the Memphis Police Department.
that is correct.
Sergeant Barbarato, how long have you been with the Memphis Police Department?
I've been employed with the Memphis Police Department 21 years.
And where are you currently assigned?
Currently assigned to the Crime Scene Investigations Unit.
And how long have you been there?
6 years.
And were you there on February the 18th, 2016?
That is correct.
And you worked at 475 Clinton? Is that,
Yes,
is
that
that
is
the
correct.
CSI office?
That is our office.
Did you have an occasion to be brought some receipts and other papers by Sergeant Smith of the
Yes, sir.
Homicide Department?
Yes, that was.
And what was the purpose of being brought to you?
He brought these articles to me to see if I could find any fingerprints, lady prints of any type, anything on them.
Tell the ladies and gentlemen briefly a little bit about your training and experience.
Sure. As I said, I've been in the Crime Scene Investigations Unit for about 6 years. During that time, I've gone through basic crime scene training, intermediate and advanced crime scene training. I've done blood spatter analysis. I'm a member of the International Association for Identification, which is the international group for crime scene personnel. Varied body investigations, over 400 hours of various types of crime scene related training is what I've gone through.
I want to pass you up something and see if you recognize this. You recognize what you can hand it?
Yes.
What is it?
What I have here is a copy of the process request form, which also acts as a chain of custody of evidence, relating everything that Sergeant Smith brought to me. Attached to it is one receipt, and the extra is a sheet, a photocopy of 3 of the receipts that were brought to me
All right.
for a
now,
process.
Before you processed the original receipt, what did you do?
I photocopied it to make sure that anything that was on that receipt was permanently documented, because the chemical process that I use will possibly wipe out the thermal print on it. So I documented those receipts, 3 receipts, which were very similar, by putting a small number up in the upper right-hand corner, so I could know which one it was after the process occurred. So that's why I photocopied it to document it.
All right. And what is the second item?
The second item, which is one of the receipts, which is actually receipt number 1.
Did you mark that on?
I did, and it's marked kind of faint, but it is up in the upper right-hand corner, which corresponds to number 1 here, receipt.
All right. Would you explain to the ladies and gentlemen of the jury what process you used, or how did you go about trying to determine if there was a laser print on
Sure.
on the receipts?
For papers and such items, we employ a chemical solution called ninhydrin hexane. It's a combination of multiple chemicals. The ninhydrin is a crystal chemical that will react with the aminos in the sweat gland. So when you touch paper, your prints are absorbed into the paper. So the typical, what you see on TV, fingerprint powder doesn't work as well. These chemicals work. So they locate the fingerprint that's been absorbed into the paper, and therefore you can see it. It'll stain it a kind of a purplish color, which is what I observed on this receipt.
All right, and what did you do with the receipt?
Once I made the observation on the receipt, I submitted it to our late print examiners for identification.
All right, and there's no objection. I'd like to have those as collected exhibit the two items.
No objection.
140?
Yes, pass it with the second.
Good evening. Now, you processed a couple different items, not just those 3 receipts, right?
Correct.
You processed 2 plastic cards, 3 receipts, and it says assorted papers. Do you recall what kind of papers you received?
I want to say, I can't say for sure that I remember exactly. I got, on my receipt here, I wrote down exactly what they wrote down. And that is 3 paper receipts, 4 paper envelopes, so that would be part of it. 1 piece of paper, which is an assorted piece of paper, odd piece of paper, and then 2 plastic cards. To be exact, what they were, I cannot say without looking at them.
Now, you did not retrieve those from where they were located, right?
I did not.
Those items were brought to you
That is correct.
by Sergeant Smith.
That is correct.
So you don't know if there was additional stuff, you just tested what you were given.
Correct.
And out of, did Sergeant Smith discuss with you the source of these papers and plastic cards and everything like that?
No, I don't recall that being part of the discussion.
So you didn't actually choose what you tested, you were given items to test, and then you tested them.
In that process, yes.
Now, as part of your testing, you were explaining the chemical reaction that happens, right?
Correct.
Now, did you take any photographs of that chemical reaction?
No, there are no photographs of a chemical reaction because it happens over time. It's very slow, so there are no. You process the paper item and then you set it and let it dry, and then the reaction slowly comes about, and then you have whatever you.
Did
result.
Did you photograph any of the results?
No, I did not photograph this. However, well, what I should say is these items, when they're submitted, are then paper items like this are photographed later, but not by me. Usually by a late print examiner, because they have to use the photograph to do what they do.
Was that receipt the only one that had a print at all come up on it?
Correct.
And that was out of those 4 envelopes, 2 plastic cards, 3 receipts, and assorted papers.
Correct.
Now, you don't know where that receipt came from, do you?
Other than Regent's Bank, as it says.
Right, I mean like where it came from before Sergeant Smith brought it for you.
No,
And you don't know how that fingerprint got there.
no, I do not.
And you don't know how long that fingerprint had been there.
Well, no.
That's all I have, Judge.
Judge, Sergeant Barbarado, he also did crimes. He also did a crime scene for this case. Sergeant Barbarado, do you remember being asked to go out to 2118 Westchester Circle with Sycamore Lake Apartments?
Yes.
On 4/11 of 17?
Correct.
What was your purpose in going out there?
It was requested by an investigator to just take some measurements of the scene or this location and area as it was directed by an investigator.
I'm going to pass you up something to see if you can recognize it. that's what you can handle.
Right.
What is it?
This is the sketch that I completed, initialed by me.
How did you go about doing your sketch, and did you go out and walk?
Right, well, what I did, it was requested to take measurements of this area based off of where the center and parking lot area. And so what I just used a simple measuring roller that measures feet, inches and feet. And just took a measurement from the curb line, the west curb line of that area, or the east curb line, into the parking lot going east. To the middle of the parking lot, such that it lines up with the stairwells, which is what was wanted by the investigator. And that was 75 feet. And then it was requested from that point to the middle of the building address of 2100. And so I measured that point from the middle of the parking lot to the middle of building 2100, which was 160 feet and 2 inches. Approximate. These were all approximate.
Okay, if there's no objection, I'd like to remark the next exhibit.
No objection.
May I publish exhibit numbers 140 and 141?
Sure.
Sergeant Alvarado, I have on the screen what's marked as exhibit number 140. Is this the Regions Bank receipt?
Those are.
Those are. Which one of them did you?
The one marked number 1, the far right, is the one that was indicated that came about and processed out.
Yeah.
So this one, right there. Number 1.
Yeah. All right, there we go. And I have on the screen exhibit number 141.
Rotate it a little. Yeah, keep rotating that way. Thank you.
How did you go about taking the measurements?
All right. As indicated, I took a measurement from this curb line to the middle of the parking lot, such that it lined up with the middle of the building between the breezeways. There's a breezeway where these stairs are. These are indicating stairwells going up. Okay, so each one of these I measured from the middle of that parking lot through the breezeways of 2104 to the middle of 2100, which is where the investigator requested me to measure to get a distance.
When you were measuring this, how long did it take you the time to measure it?
Oh, it didn't take 2 or 3 minutes to walk the terrain through all that.
But you were just walking, right?
Yes, I was just walking.
What running anything?
No.
No further questions, I've asked it.
Officer Barbarado, obviously, any of the crime scene sketches, they're not to scale, right?
Correct.
And you went out to the scene to do those measurements.
That is correct.
And I'd like to put that back up on the screen for you. Do you recall this scene?
Yes.
Do you recall this area being a parking lot?
Yes.
Do you recall seeing this building?
Yes.
And do you recall seeing this building?
I do.
Do you recall seeing anything that would have caused a major obstruction of a view from either of these buildings into the parking lot?
Well, at the time that I was there, which was, I guess, like I said, in 2017.
This year.
Right, earlier this year. There was nothing more than some cars that were in the parking lot at that point.
So nothing that, from a balcony in either one of these buildings, nothing that would obstruct the view into that parking lot?
From the balcony, I did not observe from the balcony. I did not go to the balcony.
Did you observe anything tall enough to obstruct the view from a balcony?
I don't recall anything.
Okay. Now, you said, and I believe it's notated on here, you went out and made this sketch on April 11th of 2017.
Correct.
And that was over a year after you originally processed the receipts in the same case.
Correct.
That's all I have.
Anything else?
What were you doing?
The date on the Regions, I'm sorry, Your Honor, just one other question. The date on the Regions receipt that came back with the print was 1/12 of 2016, right?
I would have to look at it again. I don't recall off the top of my head.
Your Honor, may I approach?
Yes. I need the one that,
The copies?
the copies that are legible. The date on receipt number 1 shows 1/12 of 16.
Thank you. May I approach for preview, Your Honor? Thank you.
No,
All right, thank you, sir.
Thank you.
All right, call me next.
Mitch Oliver, please. Mitch Oliver.
So you can come around and go the door this way? Stand in the circle, face the judge, raise your right hand.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I
See clear?
Good afternoon, Mr. Oliver. State your name, please.
Mitch Oliver,
Spell all of it.
Mitcholiver,
And by whom are you employed?
Regions Bank.
And what do you do there?
I'm a fraud investigator.
What is that? And what does a fraud investigator do for the bank?
We investigate any kind of fraud, anything of that nature that happens, and also any kind of court proceedings or subpoenas, things of that nature.
You were, in the performance of your duties, are you the custodian of certain records?
Yes.
And pursuant to a subpoena, I've asked you to bring certain bank records belonging to account number 184296887, is that correct?
Yes.
And who was the account holder?
When was the account open?
I'm sorry, when was the account open?
I'd have to look at the documents.
Okay, would that refresh your recollection?
Yes.
Your Honor, Ms. Hughes has these documents.
These are account statements for that account number through, appears to be January, December and January and February of this last year, 2015 through 2016.
And are those records prepared in registered sources?
Yes,
Are you familiar with the mode of preparation of these records?
yes,
Are these records made at or near the time of the event?
yes.
Are you familiar with the sources of information included in these documents?
Am I?
Familiar with the sources of information that are reflected in those documents?
Yes,
And are they made under a duty to prepare them and under a duty to prepare them accurately?
yes,
Are they permanent records?
they are.
And those records are records from the business bank?
Yes, they are.
You can mark it.
Not all of them, Judge. Here, pass this on. I've handed you the first page of that document. And, at this time, Judge, I'd like to have it marked with, just the front page.
All right. 142.
Who is the account holder again?
The account holder was Gloria A. Tate or Eddie J. Tate Jr.
All right. And can you tell if there are any transactions in January, the last transaction in January of 2016?
This statement shows a transaction of 121.
And what type of transaction was it?
It shows to be an ATM image deposit, which would be an ATM deposit.
For how much?
$309.
And the date again was 1/21/16?
Yes.
Are there any transactions for 1/22?
It does not show any transactions for 122.
No further questions. Pass it.
Mr. Oliver, an image deposit, is that a check or cash?
It could be either one.
Either one. Okay. And do you have any personal knowledge about who's responsible for a shooting at Sycamore Lake Apartments on
Objection?
January 22nd?
Objection.
Let's see what then.
He's asking, does he have anything about a shooting? Did you ask him about a shooting?
Yeah, that's what I asked. It's open cross-examination for Tennessee.
Well, do you have a good faith basis to think that he would?
I'm asking him, he might.
Well, I mean, you have to have a good faith basis to think that he might. Or just,
I know once I asked him, he's more quick than a second, that's the only question I asked for.
Okay.
Now, proceed.
go ahead.
Do you have any personal knowledge about who's responsible for a shooting at Sycamore Lake Apartments on January 22nd, 2016?
I do not.
Thank you, sir.
All right, thanks, sir. All right, calling the next witness.
Larry Preston. Larry Preston.
You want to see?
Preston, come right this way.
Go on.
Stand, sir, face the judge, raise your right hand.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so you got?
Good afternoon, Mr. Preston.
Good afternoon.
Can you say and spell your name, please?
Larry Preston, Larry Preston,
And Mr. Preston, where are you employed?
Memphis Police Department, crime scene unit, late print section.
Should I call you Officer Preston? I apologize.
Actually, just late print examiner, not an officer.
You said late print examiner. What does that mean?
That means that I examine, evaluate fingerprints, examine and evaluate fingerprints, determine if they are positive for identification. And I try to make an attempt to identify those prints to known individuals.
And do you have any, I guess, education or training to be able to do that?
Sure.
And what's that?
My original training was with the Federal Bureau of Investigation, Washington, D.C. 1974, I was trained as a fingerprint examiner for the Federal Bureau of Investigation, with whom I worked for some 9 years. That consisted of a 13-week classroom training and up to a year in actually working in fingerprint. This was prior to automation. And also was trained at Quantico on late print identification. I've had training in palm print identification here recently.
And how long have you been doing this total? Both in Memphis and DC and everywhere?
43 years.
43 years you've been a late print examiner.
Actually, started out as a regular ink-print examiner and actually got into Layton's and started working for Shelby County in 1982.
Explain to the jury what the difference is between those two.
Well, ink print is actually a print that is actually, well, it used to be, use fingerprint ink to actually roll print ink and roll it onto a fingerprint card. Of course, now we have what we call live scan, and it's computerized, it's inkless, but you would roll all 10 fingers onto a fingerprint card, utilizing fingerprint ink.
In your experience, how many fingerprints do you think you've examined? Ballpark. Thousands?
Thousands, not millions.
Thousands, if not millions. Do you have any certifications? I guess as being a late print examiner, is that a certification that you obtained?
Yes, I was certified for, ink prints. I worked for the FBI. My late print, I guess certification would be when I attended a late print examination and fingerprint class that was given at Quantico, Virginia in 1986. It was like a 3-week course. Yeah, that's basically, that's where I got my late
Have
print.
you testified before?
Yeah.
How many
What
times?
stipulates his qualifications?
I mean, that's what I can have. How many times have you testified?
Numerous. I'm not
And I guess they're going to stipulate to being an expert in late print examination.
Yes, sir.
Okay, maybe see then.
Think so. I'm going to take you back to our case involving a lady by the name of Shelby. Did you have a chance to work on that case? Sergeant Gap, right?
the late examiner, yes, but he initially worked on the case.
I guess to let the initials properly, explain to the jury what double blind testing is. What does that mean?
Pardon?
Double verification, excuse me.
Okay. What that means essentially is one late examiner, in this case, Nathan Gathright, originally handled the case. And he originally made the identifications on the prints. In our office, we have a policy, at least 2 examiners will look at a print and verify it.
And in this case, were you able to take Mr. Gaffright's work, and did you look at it?
Yes.
And what did you do with it?
I examined it and I guess you could say I confirmed that his evaluation and his identification. We have at least 2 examiners that will sign off on any identification that leaves our office.
And you had the same findings as Gaffright, correct?
Yes.
What were you asked, or what was he asked to compare?
He has one latent lift card.
Okay. And explain to the jury what a latent lift card is.
It is actually a card that is submitted by an officer or crime scene officer where they have lifted prints from an object or processed prints and lifted prints and attached to a card.
Okay, and they would maybe compare that to a known print?
Yes.
Okay. And do you know what he was asked to, where his lift card, how many lift cards he was asked to compare?
Only one lift card, and there was some other paper items.
Okay. Let's talk about the lift card first. Would, now where's the lift card come from?
I can only read what Officer Gary put on here.
Okay.
And it came from a vehicle. Well, I'm sorry. No, this actually came from in front of an iPhone screen located in driver's door in front pocket of the vehicle.
Okay. In a minute, I believe with no objection, that'll be the next number exhibit.
No objection.
All right, the next number exhibit would be 143. They come in an envelope, maybe we have to put the date on the envelope.
Mr. Preston, let's talk about how these are compared. Are they compared two different ways? A manual comparison and then another way?
Well, originally they searched on a computerized database to try to find a match, what we call a match or identification. They are identified manually.
When the computer database finds a match, what happens next? Is there a second
The
step?
examiner evaluates the respondents to the call. Actually has to do a manual comparison evaluation of the print.
So if I understand your testimony right, first there's a computer database that will flag a match, correct? And then that'll be verified through a manual comparison.
Well, the print actually will be encoded into the system and sent out to search, actually search the database and it's actually looking for a print with the same or similar characteristics as the print that we enter. It will bring back what we call respondents. And at that point, we could actually view prints, the print that we entered and also the respondent print. The computer doesn't actually match the print. It will bring back the respondents and they have to be actually manually compared.
Okay, so I guess maybe I missed, but flagged and then you manually compare it, correct?
I guess you could say that.
Okay. Now, on the iPhone lady print card first, where was there a match that Mr. Gathright found?
Yes.
And he did that by verifying it through a manual comparison, correct?
Yes.
And then you, kind of double check it, I guess, for lack of a better word, correct?
Exactly.
And who did that print come back to from that iPhone?
It came back to Gary Dotson.
Okay. Next, I believe you mentioned some paper objects.
Yes.
What were those two objects?
That was some objects submitted by Officer Colorado This is 3 paper receipts, paper envelopes, PC paper, and plastic cards. He submitted all of that to us.
Okay, and were one of those receipts tested?
Yes.
Which one?
It just says 3 paper receipts, and it was one of those receipts.
Okay, and they were able to locate, I guess maybe now's a good time. What's a print of value? What does that mean? Of value versus no value?
A print of value is a fingerprint that can be identified. It has enough characteristics, what we call characteristics, to be identified. Of course, a print of no value would be one that doesn't have enough characteristics. It would be something that, it's smudged, or it just wouldn't have enough detail to be identified.
So on one of those receipts, was there a print of value located?
Yes.
Okay. And was that print of value on one of those receipts compared through the process we talked about?
Yes.
Okay. And Officer Gafford, Mr. Gafford did that, correct?
Yes.
And you kind of double checked it, you're right. And what were both of your findings? Who did that print go to?
That print was identified Shelby Isaac.
And that would have been on a Regions Bank receipt?
I'm not sure which one it was, but it was one that Officer Barbarado submitted to.
Okay. So if Officer Barbarado would have done chemical testing on a Regions Bank receipt and submitted that to y'all, the print on that receipt came back to who?
Shelby Isaac.
Okay. Now, is there a third object test? Or a print of value found on the third object? I'm going to get it right when we go.
Yes.
And was that a styrofoam cup?
Yes.
And was the print of value lifted from the styrofoam cup, was it manually prepared
Yes, sir.
by Mr. Gafford?
Yes.
And you double checked his work as well?
Yes.
And was there a match?
Yes.
And who did that match from matches?
It also came back to Shelby Isaac.
And you have, are those cards, or tell me how to word it correctly, the cards that you're looking at for both the styrofoam cup and the Regions receipt? You're holding in your hand?
Yes, sir.
Right there. I'd ask that those be the next number to please.
No objection.
All right.
Yes, sir.
Thank you, Mr. President. I don't
Yes, sir.
have any more questions.
Yes,
I'll
sir.
pass this one.
Good evening, Mr. President.
Good evening, sir.
How long do those doggone prints last on some
I don't think there's any way of determining that. That I know of.
When you find a print on an object, means that object came in contact with that print that the person had at some time.
Yes.
And of course, you don't know the circumstances of the encounter of the receipt with the person's hand. Okay?
No, sir.
Could it come from just, I think a fingerprint come from here, passing it forward?
Yes.
If I got in a car and moved this out of the way and sat down, would my fingerprint be on it?
If you touch it, it could be on there.
And if I got in a car and put my hand on it, I think it's gonna be on it.
Sure. If you touch it, it could be. It's not be on there.
Okay. I want you to look, please, at that series of bank deposits that they gave. I think there were 3 of them. These now, those are the ones you get the test on there. Or the one that you did the test on, and you just couldn't remember which one it was. Have I got that right? That was me.
Yes, it's this is one of them. I see it was one of them receipts.
It's one of those 3 that were on the first page.
Yes, sir.
Wasn't it? Okay. And the gentleman that lifted that print, he said it was off one that was dated January the 12th of 2016. You see one on there, on that sheet. There's one there.
Yes.
That one is dated January 12th, 2016.
There's actually 2. See?
Very good. And that's the exhibit that you handed to? That's exhibit 140. The phone that you checked, you said that came back, the print on that came back to a Gary Johnson.
Yes, sir.
So the print belonging to Gary Johnson was on that phone. And that's what lifted and sent to you, right?
Yes, sir.
And you used your expertise in phone that Gary Johnson.
Yes.
Is there any prints of no value, or did you only test the ones that had value?
I only examined the prints that Mr. Gaff identified.
Okay, that's fine. Thank you, sir.
Very briefly, Judge. Mr. President, is it also possible for a person to touch something and not leave a fingerprint? Is that possible?
I suppose they depending on what the object is.
Some objects are more diffusive,
Yes.
depending on prints than others.
Yes.
Agree with that? Mr. Massey asked you a series of questions. Do you remember him asking you if he sat down and, or if he grabbed, I believe he picked up a piece of paper and waved it around? So my fingerprint would be on this, right?
More than likely on a piece of paper,
Okay.
yes, sir.
And if he sat down and moved something, his fingerprint would be on it, right?
Yes, sir.
Let's suppose, I guess going down his same line of questioning, if I had shot somebody and was rifling through their car and touched a piece of paper, could my fingerprint be on that piece of paper?
Absolutely.
Thank you. No further questions.
You have any information on that fingerprint about a person shooting anybody else? You don't, do you? All you have is a fingerprint, right? All you have is a
Yes, sir,
fingerprint.
that's all I have.
You don't know anything about the shooting, do you?
No, sir.
Don't know anything about the shooting, do you?
No,
You
sir.
weren't there at the Sycamore Lake Park?
No, sir.
Okay, I didn't think so. Thank you.
Nothing further. All right,
All right, thanks, sir. Call you next witness.
Kasha Lynch. Hang on just a second, Mr. President. Do you have anything that we marked as exhibits with it? But that's not one.
Front facing judge, raise your right hand.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Madam Again. Can you say and spell your name for the court, please?
My name is Kasha Lynch. It's KASIA-LYNCH.
And where do you work?
I work for the Tennessee Bureau of Investigation in the Memphis Regional Crime Office.
And Ms. Lynch, what do you do for the TBI?
I am a special agent forensic scientist assigned to the Firearms Identification Unit.
And what do you do in the firearms identification?
So in the Firearms Identification Unit, we receive evidence that is related to firearms, so guns, bullets, cartridge cases, anything of that nature. And I compare the bullets and cartridge cases to see if they have been fired in a specific firearm or not. In the absence of the firearm, I can try and determine how many guns were used in that crime.
And do you have any, I guess what kind of education do you have?
I have a bachelor's of science and a master's of science from the University of Florida. And as part of my job with TBI, I underwent 2 years of on-the-job training under other qualified examiners with about 100 years of experience combined. During that training, I examined hundreds of guns. I looked at hundreds and thousands of bullets and cartridge cases under the microscope and compared them, showed that I understood firearms and how they work, and that I could manipulate the microscope and perform the duties of my job.
John, those are great.
Okay. All right. And what's your book? So you are an expert in, I don't want to word it incorrectly.
Firearms identification.
Thank you. And you were asked to work on this case, correct?
Yes.
Can you explain to the jury what you were asked to do?
I received 6 bullets and a total of 7 fired cartridge cases, and I was asked to examine them. So during the course of my examination, I'm trying to determine caliber of the bullets and whether they were fired in one gun or multiple guns. I'm also looking at the cartridge cases and determining how many firearms shot those cartridge cases.
Did you were given, I don't want to speak incorrectly, 7?
6 bullets and 7 cartridge cases.
Okay, explain to the jury the difference between a bullet and a cartridge case.
I have a demonstrative exhibit, if that's okay.
Would you be allowed to show the judge?
So this is a large version of a live ammo round, what we call a cartridge. So when the evidence that I received was 6 bullets, which is the projectile that goes down the barrel towards the target, and 7 cartridge cases, which are the component that holds everything together. And these are typically ejected from a firearm when the firearm is shot.
And how do you compare them?
I have a comparison microscope, which is essentially 2 microscopes that are combined by an optical bridge. This allows me to look at 2 items of evidence at the same time under the same magnification and compare them. So with the cartridge cases, I just put 2 cartridge cases on and I compare them side by side and see if the mechanical fingerprint is on both of those exhibits. With the bullets, I can do the same thing. I'm comparing the marks in the rifling of the bullet. And the rifling are marks left from the barrel that are put into the barrel by the manufacturer. They impart spin on the bullet, which allows the bullet to be more accurate. And so these marks are left on the bullets and leave individual characteristics, which is like a mechanical fingerprint.
So mechanical fingerprint, is that the same thing or different as like a class characteristic? What am I talking about when I say class characteristic?
Okay. So class characteristics are the characteristics intended by the manufacturer. So for a bullet, they would be the number of lancing grooves and which direction they twist, either left or right, as well as the width of those lancing grooves. For cartridge cases, it would be the caliber and the shape of the firing pin impression. This would be like looking at a car, saying Ford Focus. That's a class characteristic of the car. When I say the mechanical fingerprint, I'm talking about the individual characteristics that are left by one gun on those cartridge cases. No 2 guns will have the same individual characteristic. And that's like saying on your Ford Focus that you have a dent on the passenger side door and you have a family sticker on the back. Those are going to be individual characteristics to your car.
Are you able to determine, looking at this, which manufacturer a bullet was fired from?
For bullets, based on the class characteristics, so the items, the characteristics left and intended by the manufacturer, I can input the information into a database that was created by the FBI and is maintained by the Association of Firearms Tool Mark Examiners. In this database, there is information of different manufacturers and different models guns, what their characteristics are for the rifling. So when I input my information, it gives me a list of possible guns that could have fired that bullet based on the information.
Are you able to tell which manufacturer a casing came from?
Occasionally, there are some class characteristics that are very specific to certain manufacturers, but for the most part, they are pretty similar, so it is not possible usually to determine what type of firearm shot cartridge case or which manufacturer.
Specifically in this case, what did you do first?
So first, I examined the cartridge cases, and I had 2 different calibers represented. I had 6 cartridge cases that were 9mm Luger caliber, and had 1 cartridge case that was 25 auto caliber. I compared those on the I compared the 9mm to one another on the microscope, and I determined that they had similar class characteristics, but
What does that mean, similar class characteristics?
so the shape of the firing pin is the same, and the type of marks on the cartridge case were the same. But those are the class characteristics intended by the manufacturer, and the individual characteristics that I was looking for to determine whether it's definitely one gun or not weren't quite good enough for me to determine for sure that it was one gun. So I can say that they're...
Were you able, based on that information, were you able to come to any sort of a conclusion?
that they have the same class characteristics, so they're likely from the same make and model as one another, but I couldn't determine whether they were from the exact same firearm as one another.
Does that mean that they 100% were not from the same firearm?
No, not at all.
What
I
does
can't
that
make a
mean?
conclusion either way.
So they could have been.
They could have been, yes.
I'm going to pass you, just make sure we deal with some more stuff. They did the 122. Do you recognize that?
Yes, when evidence comes into the lab, it is given a unique laboratory case number, and a barcode is put on by our evidence technicians with that case number and the exhibit number. As well as I also handwrite the case number and exhibit number and initial it, and when I seal the evidence, I also put my initials, and all of that is present.
Were those the casings, Senator, right? Am I saying the right casing? Are those casings?
Yes.
Are those the casings that you were asked to compare to this casing?
Yes, they are.
And your findings were?
That the 6 9mm cartridge cases, they have the same class characteristics as one another, but there are insufficient individual characteristics for me to make a conclusive determination as to whether they were fired in the same gun.
Are you able to include or exclude, well, before we get there, I'm going to pass you what was marked as Exhibit 138. Somebody very has that.
Yes, for the same reason, it has my handwritten case number and exhibit number, as well as the evidence barcode and the seal that I put on at the end.
And those were the bullets that you were after, correct?
These are 3 of the bullets that I looked at.
Now back to the casing. Are you able to include or exclude certain manufacturers when you compare fired cartridge cases?
Not really. I could, on some of them, I might be able to exclude certain firearms. For example, a Glock leaves an elliptical firing pin shape, whereas these all had circular, so I can tell you that it was most likely not fired from a Glock. But there's very few firearms that are that specific in their design that I can tell you based on the cartridge cases.
Okay. And can you do the same thing for bullets?
For bullets, I can create that list of firearms that could have fired them based on their rifle characteristics and the database that I used to look it up.
And were you able to do that in this case?
Yes, I was.
Did you create a report? Yeah, that was.
Yes.
If you need to refer to it, just let me know. That helps you refresh your recollection. Based on your comparisons and what you did, is it possible that the bullets that you were asked to compare were fired from a Ruger?
Are you speaking of these 3 bullets specifically?
Sure.
Okay, so 2 of these bullets had been fired in the same firearm as one another, and Ruger is on the list of firearms that could have fired them. The 3rd bullet is just a lead core, which with most bullets there is an outer jacket of metal, typically copper, and then lead inside. The lead separated from the jacket, and that causes an issue for me because the jacket is the part that makes contact with the barrel of the gun. So the lead core does not have any characteristics that I can use in an examination, so I cannot make any determination about the lead core at all.
So if I understand you right, with 2 of them could have been fired from a Ruger, as well as other manufacturers,
Yes.
but included as Ruger. One of them is manipulated, taken down enough to where you can't say either way, could have been, could not have been.
It's just a part of the bullet that didn't make contact, so I cannot make any determination as to where it came from.
Are you able to make similar comparisons with casings? Like you were able to say that it is possible that these bullets were shot from a Ruger. A Ruger is one of the manufacturers in the list that could have fired these bullets, correct?
Yes.
Are you able to do the same thing for a casing?
Because casings are a little bit more difficult, we don't have a database that says their class characteristics for one manufacturer is always like this. All of the Rugers I have ever seen have circular firing pins, as the cartridge cases did, but I would say upwards of 90% of firearms have circular firing pins. So Ruger is possible, but so are lots of other ones.
Are you able to, and if I've asked you this already, are you able to say whether or not these bullets match these casings that you were asked to do?
That's not something that's possible, because when you look at the cartridge case and the bullet, the marks I'm looking at on the cartridge case are back here, and the bullet comes out and goes down the barrel. They made contact with 2 different parts of the gun, and any marks that might have been left on from this part of the cartridge case on the bullet are going to be obscured by the marks from the barrel. So there's no way for me to determine if this bullet came from this cartridge case.
One moment. That's it.
Today's definitely there. You didn't have to call on the test for the act.
No, I had no firearms.
So you tested the bullets in the action.
That's correct.
And if I understood you right, excuse me, I'm looking at your report, this report get entered in there. After 40.
accurate copy of my report.
I looked at it,
Okay.
All right. 145.
Published what's previously been marked as exhibit 145.
Yes.
Can you see that okay? Specialized image.
Yes.
I'll make that bigger. Yeah. Okay, that better easier to see.
Yes, it is.
I want to call your attention, please, to this all down here. Is that what you were talking about when you said it's consistent with the rubric?
The first part of that paragraph talks about the bullets all being fired in the same firearm as one another. And then, based on the rifling characteristics on those bullets, that is the list of firearms that could have fired in. And in that list, Ruger is included.
Can you say that for sure that only one firearm is here?
Yes.
And that firearm then is, it's one of, you think of the bullets in are consistent with one of these types of weapons?
Yes.
Of the rifle?
Correct. There's possible that our database is not complete because manufacturers change their specs all the time. So we would need the gun to know for sure which gun. But based on the database that we have and all of the manufacturing information that has been put in it, this is the most updated list of guns that could have fired the bullets based on their rifling characteristics.
Goodness, how many guns are on this?
I didn't see it.
Armalite, Beretta, Calico, are all these different kinds of guns?
Yes, these are all different makes of guns.
CZ, that's the kind of gun?
It is correct.
Colt,
Yes.
you have to help me with this one. Daewoo,
They will, yes.
that's a different kind of gun. EAA,
Mhm.
how do you pronounce it?
Yeah.
And an WG, and I guess FMJ is full barrel jacket.
No, it is in terms of bullets, but for firearms, no.
Okay. The Cobra,
Yes.
weapon, Browning, right?
Yes.
Heckler Koch, H&K,
Yes.
and
I,
an Intertech,
yes, sir.
a Koch, a Keltec,
Yes, sir.
Luger, a Masterpiece Arms,
Yes.
a Mouser,
Mauser.
a Marenco,
Yes, sir.
a Radom,
Yep.
there's a Ruger,
Yes, sir.
Springfield,
Yes, sir.
Steen, Sterling,
Yes.
Stay,
Steyr. Steyr.
SWD, Cambodia,
Uh-huh.
Vulcan Armament,
Yep.
Walford,
Yes, sir.
Gustavia,
Zastava.
and possible others. How many possible others are there?
That's what I was speaking about. It depends on if manufacturers change their, how they make the gun, or if they just have to change the base of the rifling. It might include other guns that we do not know about.
That's about 30 of them right there, isn't it?
About,
And impossible others.
correct.
Now what about these down here, the 38 specimen, the 357 Magnum? Are they consistent as well?
Yes, when determining caliber on bullets, we're looking at the diameter of the base of the bullet, and different calibers share the same information or same diameter of bullets. So 9 millimeters, 38 specials, and 357 all have the same diameter of bullet.
So that those bullets could have been fired from these weapons too?
They could have, yes.
Wow, so that adds to those 30 and possible more.
Correct.
So there's a Astra, another Browning that's a 38 or a 357 caliber.
Correct.
Charter, XCAM, FIE, Llama, QFI, Rossi, Taurus, and there's that possible others. There's a bunch of others, could be.
Could be.
So what kind of odds, can you give it any kind of odds that it's a Ruger?
I have no way of calculating.
It's just possible, that it could be.
It is possible that.
Okay. I don't think I have anything else. Thank you.
Now that Mr. Massey moved your report into evidence, you were asked to compare bullets that were taken from a car, right?
Yes, I believe so.
And bullets taken from a person.
Yes.
Were those fired from the same gun?
Yes, all of the bullets I examined that had information for me to look at were fired in the same firearm.
Okay. Although we're not all experts like you are, Mr. Massey had a report in here. I just want to make sure it's clear. Can you see my pen? Where it says 38 caliber class, can that include 9mm?
Yes, that's why the 9mm and the 38 and 37 caliber is also. So those are examples of the calibers that are included in 38 caliber class.
So when you read this report, just because it says 38 caliber, you're not excluding a 9mm, correct?
No, not at all. That's just based on the measurement of the diameter. That measurement is considered 38 class. And then in the 38 class, you have 9mm, 38 autos, 38 special 37s, and a few others. And so those are all considered 38 class, but these bullets are consistent with either 9mm or 38 special 37s.
And one more time, the bullets from people's bodies and the bullets from the cars were fired from the same gun.
Yes, they were.
That gun could have been a Ruger,
Yes, they were.
but without the gun, we don't know, right?
That's correct.
Pass one.
You said beyond a reasonable doubt they don't.
Objection, you have the caution of legal conclusion. We know you can't do that.
Change.
You can always say possibly, can't you? Huh?
I can say that Ruger is a possible firearm.
Can you say to a reasonable degree of scientific certainty?
There's no way for me to calculate or determine. It could be any of those firearms listed. When I get a firearm, I can determine whether it's fired in that specific one or not.
There's no way for that. Thank you.
Call the witness, please.
Christy Smith. Is this an example?
Christy Smith. Hey,
Gosh. Gosh.
hang out there, right, real quick. Kind of before the next one, I think without objection or protest stipulated that the pass on that was that we didn't hang anything more. We're gonna have to do the next one.
What is that?
The bullet patch.
Okay.
Pull it back from war.
The Emmy. The bullets from Emmy.
Okay, you want to do
Oh gosh, she's good to go. Excuse me.
swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
State your name, please, and spell it.
It's Christy, C-H-R-I-S-T-I-E Smith.
You're a special agent with the Tennessee Bureau of Investigation.
Yes.
And how long have you been with TBI?
3 years.
And tell the ladies and gentlemen of the jury a little bit about your education background and training.
I have a bachelor's degree from the University of Mississippi in biology and a master's degree in criminal justice from the University of Tennessee at Chattanooga. I previously worked for the Mississippi Crime Lab for about 6.5 years, doing serology, which is the study of body fluid identification. I worked in Phoenix, Arizona for the Arizona Department of Public Safety Crime Laboratory for 10 years, doing a specialized type of DNA testing called mitochondrial DNA, which was affiliated with the FBI as part of a program to enhance the capabilities for law enforcement agencies to submit cases throughout the United States.
What is the field of forensic biology or forensic serology?
Forensic serology is the study of body fluids.
And does your work involve forensic serology?
Yes, it does. Serology is generally the precursor to DNA testing. So if a person is going to perform DNA testing, the first thing that typically people like myself do is examine items of evidence to determine if there's any sample available for DNA. And how we do that typically is do testing for either blood, semen, or saliva.
Have you testified in criminal court concerning DNA analysis for forensic serology?
Yes.
Let's get back on.
Oh, okay.
All right,
You and I attended her as an expert in the field of forensic serology.
very well, you may proceed.
Special Agent Smith, pursuant to subpoena, I've asked you to come and testify regarding lab case number 163001729. Did you bring your records?
Yes.
And you were asked to analyze certain evidence that was submitted to you.
Yes.
And if you look at the report, could you tell what items were sent to you?
The items that were sent.
Yeah, so you were asked to look at.
There were a multitude of things that were sent to us, but ultimately what I tested included a swab from a sweatshirt and known DNA standards from several individuals.
So you were sent a black sweatshirt?
That was one of the items submitted, yes.
Yes. You've been handed the items from exhibit number 145. Could you tell us what they are?
Yes, what I'm looking at is a brown paper bag that has markings on it identifying two items, a DNA swab that is from the sweatshirt and then an actual sweatshirt.
Well, you also sent other items such as blood samples from the victims, blood samples.
Yes.
And who were they from?
I was also sent blood standards from Edwina Thomas and Eddie Tate II.
And were you sent saliva standards?
Yes.
From whom?
Shelby Isaac and Victoria C. Mercedes. Not sure the pronunciation.
Now, tell the ladies and gentlemen of the jury how you went about trying to obtain these DNA comparisons. What process did you use?
The process for DNA, like I mentioned before, involves typically serology, which is the front part of that. I did that in this case, and the samples that I then performed DNA on went through a series of steps. And that included extracting or removing the DNA from the sample, determining how much DNA I have in the sample, amplifying or making copies of the DNA, and ultimately performing capillary electrophoresis, which is just a fancy word meaning that I took a portion of the sample and it was run on an instrument that was ultimately able to interpret and collate the data for me so that it is in a form that I can visually see the DNA profile. I also did that for the known standards as well. And then once I have both of the pieces of information, I can compare the two to see if they match or do not match.
And what were your findings in this case?
For my item 5B, which was a swab from a sweatshirt, the preliminary test that I was telling you about, those were positive that indicated the presence of human blood. And then the DNA profile that I obtained was a mixture of at least two individuals. And the major profile, which is the person that contributed the most amount of DNA, matched Eddie Tate second. And the minor profile, which is the person that was detected that contributed a smaller amount of the DNA, was so limited that I was not able to do any comparison to determine who it did or did not match.
So there was a major contributor and a minor contributor.
Yes.
How did your comparison reveal anything about Shelby Isaac and Victoria Say?
My report that I'm looking at says that the major DNA profile matches Eddie Tate, and it also says that it does not match Edwina Thomas, Shelby Isaac, or Victoria Say.
That means their blood.
The major contributor, or the person that contributed the most DNA to that particular stain, matched Eddie Tate the second.
Based that on a statistical determination.
Yes, I did perform statistics on that match, and the statistics that I determined were the probability of randomly selecting an unrelated individual with the same major DNA profile is 1 and a number greater than the current world population.
That's small difference. So you determined that the major contributor was Eddie Tate. Is there a minor contributor that you were not able to determine?
That's correct.
And do you know if that's, why is that?
Sometimes when we obtain mixtures, the person that's contributing the minor amount of DNA to that sample is just in such a low amount that we're not able to detect it. Or sometimes what can happen is when you have DNA in a stain that where the person that contributed, say the blood stain, there's a lot of DNA there. If there's cellular material from a second person, for example, sometimes the DNA from the blood donor can overwhelm or overpower the person that contributed a smaller or lesser amount. Kind of like if you had a gallon of tea, for example, and you put in 1 grain of sugar, you know the sugar's there, but can you actually detect it or taste it? In the same way, our testing works in that we have to have a certain amount to be able to detect it.
So were there 2 people?
I was able to conclusively say there's at least 2 people in this mixture, yes.
But you can't determine who they are.
The major person matches Eddie Tate the second. The minor was in such a small detected amount, I'm not able to say who it matches or doesn't match.
No further questions, I'll pass it.
Especially if it's the, now these samples were sent to you by J.K. Smith, right? J.K.
Yes.
Smith. And he's with the police department.
Yes.
And he provided samples to you. You didn't request particular items, right?
Correct.
And among those items, you were sent saliva standards
Yes.
from Shelby Isaac and from Victoria C.
Yes.
and you were sent blood standards from Edwina Thomas and Eddie Tate II.
Yes.
Were you given a saliva standard for a man named Gary Dodson?
No.
If you had been given that standard, would you have tested against that?
If I had been provided that standard, I would have run it as we run all standards when we receive those in cases. I could have run it and then compared it to the major profile to say essentially that that person could have been excluded because I know already that that major matches Eddie Tate. Eddie Tate II, I'm sure I get the name right. But for the minor profile, if I had had another sample or 12 more samples or 20 more samples, I would not be able to do any comparison or interpretation. I determined that on the very front end that it was too limited, that I cannot do an inclusion or an exclusion.
And the standard, or I'm sorry, the sample that you're talking about on your report, you said is 5B, right?
Correct.
And that on your report is the swab from the sweatshirt,
Yes.
not the actual sweatshirt itself.
Correct.
So you didn't test the sweatshirt, only the swab.
Yes.
That's all I have.
Just test the DNA swab, is that you?
Occasionally, and I just wanted to mention as well, that swab came to us. It's not a swab that I took from the sweatshirt or collected from it. Occasionally, we will get samples where the police department or the police agency has collected a sample, and that's what happened in this case. I wouldn't say it's common, but it does happen from time to time.
You only tested what you were provided, right?
I tested the swab, which was one of the items that I was provided, yes.
That's all I have.
Thank you, ma'am.
What we have are where we made, between the defense and the state, where we discussed what we wanted out.
If Your Honor wants to see this, this is it goes through the transcript of the call. It has scratches on it that Ms. Hughes and I both used to come up with the redacted version, explaining what was redacted from the call.
I guess, just so the record's clear, that Ms. Hughes had that transcript.
Okay. So, the parts in blue, the ones you redacted? Yes.
Judge.
That's
And I can make an additional note of that. I'm trying to write redacted next page one.
Now, in the regular jury charge, we have a standard charge on impeaching a witness. And then there's a part of that talking about prior inconsistent statements. And right after that, I've added a paragraph talking about prior consistent statements. It reads as follows: when a witness's credibility is attacked by a suggestion that a witness's testimony is fabricated, whereas a deliberate falsehood, the prior consistent statement may be introduced for the sole purpose of corroborating the witness's testimony. Prior consistent statements may not be admitted as substantive evidence of the truth of the matter asserted in such statements, and are admissible only to rehabilitate the witness's credibility. Because, see, that distinguishes it from prior inconsistent statements, that if they're in writing, or if they're under oath, or if they're audio recording, then they can be used as substantive evidence. So this distinguishes the prior consistent statement.
Is that not consistent statement from the pattern?
Pardon?
Is that from the pattern jury instruction?
No, we don't have a pattern jury instruction.
That, the last part of the consistent statement, should it be for the jury's consideration as to, for your consideration as to, whether
Sorry.
There is no pattern jury instruction for prior.
I know, I was looking at the pattern instruction for credibility. I want to say that it's mentioned, but. prior
That's what
consistent
Your Honor was
statement.
just reading from, right? The general.
There's the pattern instruction on credibility, I believe, I'm trying to check it, I believe it talks about prior consistent statements.
It's
I just want
also
to make
for
sure.
rehabilitation and it's for the jury's consideration is to give it what weight it deserves. How about that?
Well, the only way you can give it is to whether or not the witness was credible, because it's not a subject of evidence. So if I add that, you're going to think that it might be treated as subject of evidence.
Can we give them that instruction prior to learning it, so that they know it's not substantive evidence?
We should maybe tell them what's
It might draw more attention to it than what you want.
I guarantee if we poll them, not a one of them knows what substantive evidence is.
There's nothing in the credibility of witness.
There's not, that's okay, I was making sure. For some reason, I thought there was.
I just don't want it to sound like it does, but it doesn't. That's for their consideration as to what weight to give it toward rehabilitation, which is a fair way of looking at that.
Well, I think that wording is included in the wording you're looking for, I think, is in the standard instruction on a statement of admission. If a statement was made, you can give it whatever weight you think it's entitled to. I can add that. I think, I can find that. So that can be the next piece of evidence?
Yes. I believe you want that to be next, right?
Yes, yes,
Got
sir.
it. Play this first.
Yeah, that's fine, please.
Now, you want me to, like I say, sometimes not giving an instruction contemporaneous to it, it might draw more attention to it than what you want. You just say that you will file with your instructions. It doesn't matter to me.
Your Honor, would you read that part again, what you're going to tell them?
Well,
Do they add any part of that for your?
I was going to have it at the end of the standard jury instruction on impeaching a witness. It talks about how a witness may be impeached by proving the witness has made some material statements out of court that are at variance with the witness's evidence on the witness stand. I think y'all cross-examined on stuff like that. And it's pretty long. And it says, if a prior inconsistent statement of the testifying witness is a witness statement signed by the witness, or is an audio or video recorded statement, or is a statement given under oath in proof of such prior inconsistent statement, may be considered by you the subject of evidence of the truth of the matter asserted in such prior unrecorded statements. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements, However, in material discrepancies or differences in statements of witnesses do not affect their credibility unless it should plainly appear that some witnesses will be testified falsely. When a witness is thus impeached, the jury has the right to disregard the witness's evidence and treat it as untrue, except where it's corroborated by other credible testimony or by facts and circumstances proved on the trial. When a witness's credibility is attacked by the suggestion that the witness's testimony is fabricated or is a deliberate falsehood, a prior and consistent statement may be introduced for the sole purpose of corroborating the witness's testimony. Prior consistent statements may not be admitted as substantive evidence of the truth of the matter asserted in such statements and are admissible only to rehabilitate the witness's credibility. So it's all in one.
Yes, and that's what I think we're gonna put in the last, it's up to you to find the
Right.
way to get that. Fine.
Right, and I was trying to find that particular wording. It would be under conditions, I guess. I would have to delineate, I would have to say something like, the weight you are to give this pertaining to witnesses, rehabilitating the witness' credibility, is for you to determine, or something like that.
Give your
Correct me if I'm wrong, but isn't any of that language in your honor's standard jury instructions
On a statement, on a statement of admission, but it's not in any way.
not just statement of admission?
And we don't have one, right?
No.
Okay, so,
I think the same thing don't have to apply. So if you give it such way as you just take it was up.
right, there will be something like that. We can clarify that before we usually discuss the jury charge. But my question is, do you want me to give some sort of instruction now, or do you want to just wait till the closing argument, to the closing instructions?
I mean, my suggestion would be to play it normally. I mean, we don't give credibility instructions before every witness testifies. I mean, I think we should all.
But
we should all
witness's
treat it the same.
testimony is substantive evidence. I think that the jury needs to know before they listen to it that this is not substantive evidence. This is just an attempt to rehabilitate the witness.
I agree.
I think we should treat it like everything, but, I mean, I'm not pitching a fed up.
I'm trying to find that language. I'd rather have it down pat before I try to make up something. All right, so is this what you want me to add, something like this, Mr. Massey? And at the end of the confession, it says, "You are the sole judge of what weight should be given to such statement." So, I can modify this and say, "You are the sole judge of what weight should be given such prior consistent statement. If you decide that the statement was made, you should consider it with all the other evidence indicates in determining the credibility of the witness."
That's true, that kind of swept on you from festival.
That's what I mean. That's why. I want them to know that it can't be used as substantive evidence. So if I talk about weight,
What about this
When you talk about weight, you're usually talking about substantive evidence.
Can we not just say this is for rehabilitation purposes, not for evidence purposes?
Yeah, that's what this paragraph says.
That's just a different wording way of saying it. I mean,
The language says, prior consistent statements may not be admitted as substantive evidence of the truth of the matter asserted in such statements, and are admissible only to rehabilitate the witness's credibility. That's what I
You can decide what way to give it. There we go.
Judge, we have no objection to Mr. Massey's add-on. If Your Honor chooses to add the sentence, you are to decide what weight to give that evidence.
For well, it's not evidence.
What weight you are to give that statement. How about
Or
that?
rehabilitation. What weight you are to give that for rehabilitation purposes.
Judge, could we say, I don't mean to be nitpicky, but for determining the credibility of the witness, because for rehabilitation purposes implies, that she's,
That's what this is
For
for.
rehabilitation.
it is, Judge, but it says it's to rehabilitate her credibility.
She ain't got it.
And that's why I wanted to say to rehabilitate her credibility, or to determine the truthfulness of the witness. It seems like they want the word rehabilitation to be in this instruction as many times as possible to make the witness sound worse.
No, it's so that they know that it's not evidence. This is rehabilitation material. It is not evidence.
That's why I thought, that last sentence says I already had it, which is why. Prior consistent statements may not be admitted as substantive evidence of the truth of the matter asserted in such statements, and are admissible only to rehabilitate the witness's credibility.
It's fine with us.
And I would just say, you, the jury, can give it whatever way you want to for rehabilitative purposes.
And that's just overkill.
And you have no objection to that?
Well, just no, we had no objection to, and you are to consider what weight to give it. And then Ms. Massey wanted to add the word rehabilitation one more time, or Ms. Hughes.
But it's to make it clear, you're not giving it evidence or weight to evidence, because we're going to talk about the weight of the evidence many, many times. You just say what weight you're going to give it. It sounds like you're making it evidence. So just to make it clear that it's what weight for rehabilitative purposes, not evidence.
That is the purpose.
Your Honor, if I may. Reading from Tennessee Pattern Instructions 42.04B. It says alternative instructions to witnesses about halfway down the paragraph. That standard instruction says, and it's talking about different statements. But when you cannot reconcile the statements of different witnesses, you then must decide which witness or witnesses that you believe in, how it is according to his or her testimony. You do not have to accept or reject everything what is said. You're free to believe all, none, or part of any testimony.
That's about evidence.
So you want me to just add, you are the sole judge of what weight should be given such statement for rehabilitative purposes?
Yes.
Sounds good to me. All right, let me read it again. When a witness's credibility is attacked by a suggestion, the witness's testimony is fabricated or is a deliberate falsehood. Prior consistent statements may be introduced for the sole purpose of corroborating the witness's testimony. Prior consistent statements may not be admitted as subject of evidence of the truth of the matter asserted in such statements and are admissible only to rehabilitate the witness's credibility. You are the sole judge of what weight should be given such statement for rehabilitative purposes. That sound good?
Yes, sir.
All right, the state has no objection to that? Other than what you already worked. All right. And then, of course, I'll add that to the final. So you want me to give that before we do this?
Yes, sir.
All right. Sure you ready?
What's your last number? Amber. What's the last number? Do we keep sure to get the
I don't think so.
Okay.
I want to make sure.
You want to take that date?
Permission to tell them when you're about to hear.
Judge, I was just going to say, pursuant to agreement, state is playing a jail call from Victoria C.
Does it have a date and time and all that?
It does, Judge, under the jail.
And it says all that, this is being recorded.
Yeah.
Let's go back to that.
All right, State, you have something?
Yes, Judge. Pursuant to agreement, state is playing a jail call from Victoria C. And some parts have been redacted by agreement as well. So there will be some sound objections.
Minutes by agreement?
Yes, Judge. Our objection has been noted.
Call, press 0. Please enter the area code.
If we could do it before.
Ladies and gentlemen, this statement is what sometimes they would call a prior consistent statement, okay? When a witness's credibility is attacked by a suggestion that the witness's testimony is fabricated or is a deliberate falsehood, a prior consistent statement may be introduced for the sole purpose of corroborating the witness's testimony. Prior consistent statements may not be admitted as substantive evidence of the truth of the matter asserted in such statements and are admissible only to rehabilitate the witness's credibility. You are the sole judge for what weight should be given to such statement for rehabilitative purposes. Okay?
May I have
The phone number you are calling now. Please state your name at the beep. Please hold. Please wait while your call is being connected. from the an inmate at the Shelby County Jail. To accept this free call, press 0. To refuse this free call, hang up or press 1. Hello, this is a free call from an inmate at the Shelby County Jail. To accept this free call, press 0. To refuse this free call, hang up. This call is from a corrections facility and is subject to monitoring and recording. Thank you for using GTL. Hello. 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 Where will you? Hello. Where will you? You got me. Keep going. Keep going. I'm trying to keep you. I got 3 counts of especially after the fact of first-degree murder. But I've never tried the whole night, so trying to punish. Sorry. Hold on, look back. Hello. Hello. What you doing back? I really, what's wrong? I said 3 counts of seriously after the effects of her stealing my notes. What? She only killed all of them. They thought this lady and her baby was gonna make it. They died. You said Shelby? Yeah. What's up? Hello. I know you, bro. I know you. I know you. I didn't even notice you were going to have me. She started showing me. She started running. It was the people's car and they understand. They was like, oh, it was some persuasion. Oh my God, who you know I'll be around stuff like this. I check with anybody, anything. But when it comes down to the witness, you know I ain't even none of this. So when she had really bought some of her from the last 15. She had paid like $250 for it. She was like, she wanted her money back. She thought she was gonna give us some of hers when we get out the car. The man was calling to her about the window. She had just started screaming. I heard the first gunshot. I just ran. I had bail. And I just ran. I had got in my car. You know what to do. I was panicking. You know, I don't be around stuff like that. Yeah. I hate that my team. I'm sure I hate that my team. I'm just like, why they came to my house and stuff. And then they had told my mom, just like, oh, my mom, I ain't want to come home. I knew they was going to do this. They just like come down there for questions and stuff. You know, they had told me, like, don't talk to them without no lawyer. You see black lady that was in there. She was just sitting and she was like, talk to them. She was like, I'm trying to help you. She was like, if you don't talk to them, then you gonna go to jail. You know this shit, we got 3 counts of first-degree murder. Fool, they thought they taping out my name because I was saying, listen, I was lying to that girl because you know I'm loyal, fool. When they thought they taping her, they mad for me in the head because you said I was going to jail for first-degree murder, 3 counts. That's when I told, and I don't care. I told. I ain't tell nobody. I ain't call my mama. I was scared. I didn't know what to do. I didn't even know she had killed the pizza. She got in the car. Cause I had called her when I heard the gunshots. I ran. I got in my car and I drove out. So I called her. Cause she wasn't answering this stuff. So I thought the dude had shot back at her. And she answered. She was like, she was okay. Come get up from the front of the apartment. That's what I did. But when I was downtown listening to what the people were saying, they was like, Shelby rode the dude. So needlessly saying, pushed the dude out the car. She got inside the car and drove off. I don't know if she had put that car in stuff. I called her first. She said this dude that we know, he know people that work with the jail people. She gonna call him and see he say, but it don't matter. I ain't gonna get no job or nothing. Feelings. My car gonna get to all that. I already know. TJ made some find it out there on fire me. They was asking me, like, who was I in the college? I don't think I was in the college shape. But I had like, she was light skinned, I just like that. I was thinking if they was going to go through my phone, some probably get my phone to my mom. So I came in there, they was like, so you told us this shade was light skinned and fat, and I was like, yeah. And they showed me a picture of the shade. They was like, why you lying? So I couldn't say nothing, I was caught. And so then I had told them that I had parked in the back of the apartment. When I got out, this man with the gunshot. The people had seen my car parked up on the side. So you know, I always back park my car. And the people had seen my car back parked. And the police and I was like, they said the people were saying that eyewitnesses were saying when the gunshots went off, you went crazy. Because like you panicked and kept on saying, oh my God, somebody else. But I got in my car because I was scared. So the lady was a black lady and she just kept on talking to me. She was like, I know you can shoot these people. She was like, I could look at you and say that you didn't do it. She said, but I know that you was with the person who did. She was like, well, stop lying for them. Quit lying to them. I said, I ain't lying to nobody. I'm not lying to nobody. She was like, yes, you is. Just get them up, get them up. She was like, you want to know why you can't? Because the gunshots was right next to you. That's why you can't. I just kept on lying straight. I went to sleep for about like 3 or 4, like 2 hours or something. They came back in there, they still talking. So then this man came there, you know, they be talking about like damn curry people. Because I had really got Darren too. I don't know what Darren was telling. Darren was telling him shit that he was feeling. He been heard about Gary, you know. They put Gary and Marcus and all of this shit and everything. And then the lady that just came back up in there one last time, she was like, I can get it in, though. She was like, you can tell me the truth so I can help you and you can go on. But she was like, you keep on lying, you gonna have first degree murder. It's crazy, but the people saying second degree. I had just said, this old girl, and this all I could do. And I had just said Shelby. I was like, Shelby. I said, Shelby what? And I said, Shelby keep them people. Shelby keep them people. And then the lady was like, I knew you knew the kids. And she was like, the eyewitnesses said, the girl we had, she was like, why did you ask me about her clothes she had on? And I told her, they said, we know she had a baby jacket on. We know she had a real big social shirt on. They said, we knew that all the people had told her she was like, but you lied. And this what made it so worse upon you. Then they had to put Shelby up on three-way. Up on speakerphone. She was even lying. She was like, I haven't seen Victoria today. And bad to me, so they was like, you see, she ain't lying to you. They was like, if this was your real big bitch, then she would have flew down, and if she would have came down there and testified that you ain't do this. They was like, well, she ain't do this, because she ain't your friend. She ain't your friend. That's all they had. Just get off.
That concludes the jail call, Judge. State news was in as the CD of the redacted call and evidence, as I believe, number 167. Is that correct? For ID purposes only.
167?
Yes, Judge.
Now, the last one I had was 146.
Oh.
I think we pre-marked.
We pre-marked from 147 to what? 166.
Your Honor, as to the jail phone call, that jail phone call occurred on January 23rd, 2016 at 7:14.
Right.
I think it's
7:14
yes,
a.m.?
7:14 a.m. January 23rd, 2016 a.m. 7:14.
Okay, so that'd be 167? Right.
For ID. And the transcript, have we already marked it for ID purposes? We'd like to mark it for ID purposes as well. That includes the redaction part. In case there's ever an issue about what was redacted.
Ladies and gentlemen, as said, this is not considered substantive evidence for the truth of the matter in the statement this last into evidence. We have to hear it, and we will proceed. Oh, yes.
Judge, I need to change the exhibit number on this. State calls Dr. Marco Ross, please.
that nothing but true self of God. Mr. Revere.
Good evening, Dr. Ross. State your full name and spell all of it, please.
Marco, M-A-R-C-O, Ross, R-O-S-S.
And then you're medical assistant medical examiner for the county of Shelby.
Yes.
And you're at 637 Poplar. Please tell the ladies and gentlemen of the jury a little bit about your education and training, please.
I received my medical degree from Tulane University in 1985. Completed a residency in general surgery at the University of South Carolina in 91. Served in the U.S. Navy as a surgeon in 91 to 95, and completed a residency in anatomic and clinical pathology at the University of Vermont in 91, and a forensic pathology fellowship at the University of North Carolina in 2000. Served as a medical examiner in Phoenix, Arizona for approximately 2.5 years, then in Spokane, Washington for approximately 4.5 years, and I have now been here with the Memphis Shelby County Medical Examiner's Office since March of 2007.
Thank you.
Which get you like this for this?
He's a him as an expert in the field of forensic pathology. Dr. Ross, tell the ladies and gentlemen of the jury what forensic pathology is.
Forensic pathology is a branch of medicine that deals with studying those diseases and conditions that can result in injury and death.
You were asked to examine a couple of bodies on January 22nd, 2016. Do you have the ME number for Mr. Eddie Tate?
Yes,
What is that?
2016-0122.
And what did you do to that body when it was brought in?
We performed an autopsy, which involves making an external examination of the surface of the body, looking for evidence of disease and injury, and then making incisions in the chest, abdomen, and in the head, likewise to examine the internal organs also for evidence of disease and injury.
All right. And what evidence of external injury did you observe?
On Mr. Tate, he had a gunshot entrance wound on his lower front chest wall. He had a gunshot wound to the left forearm with an entrance on the back side of the forearm and an exit on the underside of the forearm. He also had a gunshot wound to his left upper arm and a gunshot wound entrance on the front inner part of the right thigh and exit on the front outer part of the right thigh.
Judge, we have a total of 19 autopsy photographs. I'm going to place on the screen what's been marked. Exhibit number 149. Those describe the external injuries that you observed for Mr.
Yes.
Tate. Yes. Could you diagram that? What you have? Please describe the external injuries.
This is a gunshot entrance wound on the front part of the chest. On the forearm, he had a gunshot entrance wound on the back part of the forearm and an exit wound on the underside. He had another gunshot entrance wound here on the back outer part of the left upper arm. Then a gunshot entrance wound here on the front inner part of the right thigh and an exit wound on the front outer part of the right thigh.
I have on the screen what's marked as exhibit number 150. What does that show?
Those those show the gunshot wounds in the order in which I describe them, hence that's the numbering that they receive, and delineates more which are entrances and which are exits. Gunshot wound number 1 is an entrance only. Gunshot wound number 2 had an entrance here, exit here. Number 3, entrance only here. And gunshot number 4 on the thigh, entrance here and exit there.
Could you repeat that again?
An entrance wound here, an entrance wound and an exit wound here, entrance wound on the left outer part of the arm, and entrance wound on the inner part of the right thigh, and an exit wound on the outer part of the right thigh.
I have on the screen what's marked as exhibit number 147. What does that show?
That shows the entrance wound on the front middle part of the chest.
And I have on the screen exhibit number 148.
This is a gunshot entrance wound on the back of the left forearm.
I have on the screen what's marked as exhibit 156.
This is a gunshot exit wound on the underside of the left forearm.
Exhibit number 155.
This is a gunshot, this is the left arm. The back is this way. Here the head would be up here towards the left. Feet are down towards the right. The chest is here towards the bottom. So this is the left arm coming up to the left shoulder. This here is a gunshot entrance wound on the left arm. The bullet actually traveled into the chest, and as it traveled by the armpit area, it caused a defect here in the armpit.
Exhibit number 154.
Gunshot wound to the right thigh with an entrance on the inner part of the thigh and an exit on the outer part of the thigh.
Exhibit number 151.
This is an x-ray of the chest. The head would be up towards the right. This shadow here represents the heart. The feet would be down towards the left. This is the right chest area, and this is the left chest area. The right lung is over here, and this is a bullet within the right lung.
Exhibit number 152.
This is a photograph of the bullet that we removed from the right lung.
Exhibit number 153.
This is a bullet that we removed from the right chest wall. This corresponds to the gunshot entrance wound on the middle front part of the chest. That bullet traveled just through soft tissue, fatty tissue and muscle in the front part of the chest wall and ended up over on the right outer part of the chest wall.
Was there a toxicology report done?
Yes.
What was the result of that?
There was no drugs of abuse were detected.
Dr. Ross, based on your training, experience, and education, do you have an opinion as to the cause of death of Mr. A.D. Tate Jr.?
Multiple gunshot wounds.
And the manner of death?
Homicide.
Now, Dr. Ross, you also performed another autopsy on Edwina Thomas.
Yes.
And what is that autopsy number?
2016-0124.
Did you observe any external injuries on her?
Yes, she had a gunshot wound to the abdomen, and she actually had surgery done in the hospital before she expired. And based upon the surgery that they performed in my examination, that gunshot wound to the abdomen had perforated her left kidney, intestines, and the major artery and vein inside the left abdomen, left side of the abdomen. In addition, she had a gunshot wound to her left forearm with an entrance on the back part of the forearm and an exit on the underside of the forearm.
Yes, I have on the screen exhibit number 162. Describe that.
This is a diagram showing the location of gunshot wounds and other artifacts related to a surgical intervention. This here represents the incision that was made in her abdomen by the surgeon. This denotes the actual gunshot wound defect on the left upper part of her abdomen. In addition, she had a gunshot entrance wound here on the back part of her left upper arm and a exit wound on the underside of her left forearm.
Exhibit number 1. Exhibit number 152. Did you also draw this diagram?
Yes, this one shows just the gunshot entrance wounds and not all the other things associated with the artifact of surgery. So again, the entrance wound on the left upper part of the abdomen, an entrance wound on the back of the left forearm, and an exit wound on the underside of the forearm.
Exhibit number 159.
It's a photograph taken of the deceased at the time of the autopsy, just a profile shot for identification purposes.
Exhibit number 165. What does that show?
That just shows an area of bruising on the right forearm. That's an area that probably is related to medical intervention where IVs were located. You can also see part of the intravascular catheter up here going towards the shoulder.
Exhibit number 166.
This one shows that there are some scars on her left upper arm. She also has a chest tube medical intervention in the left chest wall. In addition, you can see on the left upper abdomen area, this defect represents the gunshot entrance wound. And then down here on the forearm, you can see the entrance wound on the back part of her left forearm.
And exhibit number 158.
It's a photograph showing the palm of her left hand.
There's no entry there.
No.
Exhibit number 163.
This is an x-ray taken of her abdomen at the time of autopsy. A lot of these objects here actually are related to various surgical sponges that were still in her abdomen used to soak up blood. This here represents the bullet that was located in her right pelvic sidewall.
Exhibit number 164. You see that another?
Yes, it's another photograph that shows down a little bit more down in the pelvis, and this here represents the bullet in the right pelvic sidewall.
In examining bodies, particularly female bodies, do you do what's known as an examination of the genital urinary tract area?
It includes an examination of the internal genitalia, yes.
And what did you find?
That she was in the first trimester of her pregnancy.
And did you tell particularly how old the fetus was or embryo?
By the size of the fetus, in the 6 to 7 week range.
And did you take a photograph of that?
Yes.
Exhibit number 161. Describe what you see.
This is the open uterus. This here represents the amniotic sac, and the fetus is down here in the lower part of the sac.
Did you do the toxicology report?
Yes.
What were your findings?
It was negative for drugs of abuse.
Based upon your education, training, experience, do you have an opinion as to the cause of death of Edwina Thomas?
She died as a result of gunshot wounds to the abdomen and the left forearm.
And the manner of death?
It's classified as a homicide.
Based upon your education, training, experience, do you have an opinion as to the cause of death of this 68-week-old fetus?
Would have been secondary to the maternal death from the gunshot.
Oh, thank you, sir. No further questions, I pass it.
Good evening, Dr. Ross.
Thank you.
As a general matter, these were homicides, right?
Yes.
Now, nothing about your findings can indicate who committed that homicide, right?
Correct.
Now, I don't have very many questions for you, but I want to start with your evaluation of Mr. Eddie Tate. Okay? You did not receive his body from the hospital, unlike Thomas, is that correct?
Correct.
So with him came personal effects.
Yes.
And among his personal effects were, he had headphones,
Yes.
he had his wallet,
Yes.
miscellaneous cards,
Yes.
papers,
Yes.
2 quarters,
Yes.
4 dimes,
Yes.
1 penny,
Yes.
and 25 $1 bills.
Correct.
All of that was on his person when he came to you.
Yes.
Did you review any clothing of Mr. Tate?
We did look at the clothing to ascertain for defects that, we found defects in the jacket and the shirt he was wearing that corresponded to the gunshot entrance wound on the front of his chest and some of the gunshot wounds on his left upper extremity. And there were also defects in the pants, boxers, and boxer shorts corresponding to the gunshot wound to the right thigh.
And one of the things y'all look at when you're looking at clothing is the presence of soot.
Yes.
Right? What is soot?
Soot is a combustion byproduct of gunpowder burning.
Okay, so basically, when a gun fires, it shoots stuff out,
Yes.
and that can be used to determine the range of fire.
Possibly, yes.
So, if someone was standing, what are y'all's general guidelines on that? If soot is present?
Well, if soot is present, we'll make note of that. We can see it by visual inspection. But things can be altered by either the amount of blood on the clothes or the coloration of the clothing. So sometimes we can't determine. There may be some soot there, we just can't see it because of color and blood on the clothing. And only, there's some kinds of testing, I think, that the firearms people can do to look for soot, but we don't do that.
Okay. And in this particular case, you did not find any soot?
Did not see any by visual inspection. That's
So you were not able to determine the range of fire?
That is correct.
And that means whether the person who was shooting was close or far away.
Correct.
Now, I want to talk to you about the trajectories involved. Okay?
Yes.
The trajectory of any of the, when you say entrance wound and exit wound, that means the same bullet went in one place and came out another, right?
Correct.
And the bullet, there was one bullet that did not exit on Mr. Tate.
There were 2 bullets that did not hit.
2 bullets, okay. Where were they located?
The bullet entrance wound on the front part of the chest went through fatty tissue and muscle in the chest wall and ended up in being located at the right chest wall. The other bullet that didn't exit, that one went in the left arm, went across the armpit area, went into the chest, went through the left lung, the aorta, the spine, and ended up in the right lung. We recovered that bullet. Then there was an exit wound, entrance, exit on the left forearm, and then an entrance and an exit on the right thigh.
And it is possible for one bullet to cause more than one entrance wound.
Yes.
Now, as to Ms. Thomas,
Yes.
You identified 2 different x-rays on Ms. Thomas.
Yes,
Those were of the same bullet though, right?
yes,
So there was one non-exiting injury as to Ms. Thomas.
correct.
And this is normal in every case shooting, you evaluate the deceased.
Yes,
And this just tells you how someone got it.
yes,
Doesn't tell you who killed them.
correct.
That's all I have.
Any further questions? Thank you, sir. All right, State, may call your next witness.
That's the state's case. State's case.
All right. Ladies and gentlemen, the state has rested the case. Well, it's 20 after 7 in the evening. At this point, as I told you, I think in the pre-trial talk that I said, that we would have to have a jury out at this point. So I'm going to ask you to step out and we'll decide whether we're going to keep working or wait till the morning, okay? So, all right.
Your Honor, at this time, we would like to make a motion for judgment of acquittal. The evidence used in the light most favorable to the state does not support the charges listed in the indictment. The only person putting Ms. Isaac on the scene of the shooting is Ms. Victoria C., the co-defendant. As Your Honor is well aware, there has to be more corroborating evidence than just what a co-defendant says. In this situation, anything, the fingerprint as an implication, as he testified that Ms. Isaac had gotten into the car at McDonald's with Mr. Tate, which diminishes that evidence's weight as her being in the vehicle. Additionally, there was not a single witness that said that she went into the vehicle to support that. Your Honor, we would submit that this is appropriate for dismissal at this time.
First response, Judge, Your Honor, circuit free. First, we have Ms. Say, who did place the defendant on the scene, so Ms. Say made a statement of admission. And I believe, made a statement of admission to Ms. Say, claiming responsibility for this crime. Circumstantially after that, we have Gary Dobson, who the same day sees the defendant come into his home. There's blood on her clothes and a pistol with only holding 3 live rounds. Again, that is on the same day. We then have multiple, you heard from Officer J.K. Smith, who told you what he did in his investigation, how it lines up with the witness's testimony. We had multiple crime scene officers come in and corroborate that there was in fact a shooting at that place. They told you what they found. We have multiple pieces of evidence that came in through them. We also have multiple lay witnesses, and depending on who we know that goes back to Maddox, Springer Davis, came in. We were able to hear the gunshot. shots on Mr. Huntley's security camera video. Ms. J is seen leaving, what many people call scared, afraid, and no one got in the car with her or let's see. We then had in the victim's car a Regions Bank receipt in a car that looked to have been rifled through that had the defendant's fingerprint on it. In Ms. Day's car was a styrofoam cup that had the defendant's fingerprint on it. We've established that the defendant purchased, or there's proof that the defendant purchased hair in cash that day, and no cash was found. And the medical examiner testified that this was in fact a homicide that caused both the deceased passed away. The TBI Ballistics expert testified that the bullets all came from the same gun, and that gun could be or would include the same type of gun that Gary Dotson saw the defendant with on that day.
Submit, Judge, and like Mr. Everyone state, we think that this is a question of fact to show the jury.
Well, taking the case in the light most favorable of the state, reviewing the evidence, it becomes just a jury question as to whether or not the jury wishes to believe what Ms. C had to say about the statement of admission, about saying that the victim had said that she don't shoot me or something to that effect, I'm pregnant. And of course she was an eyewitness. The proof was that after the shots they heard this screaming. It was something like, oh my God, that kind of goes along with what Miss C had to say. She leaves. She takes off. So it's not really clear whether or not, from the facts that I've seen, she was actually an accomplice.
She's charged with accessory.
Well, she might be charged, but in actuality, other than coming to pick her up, that was the only thing I could see that would qualify as being an accomplice. I mean, we have two definitions, two jury charges on it, and 4209 and 4209A. And if you look at those, we have accomplice is a person who knowingly, voluntarily, and with common intent with the principal offender unites with him or her in the commission of the crime. So that would mean that they would have to have the common intent to rob, shoot, kill, whichever crime you're talking about. So being an accessory after the fact, that doesn't seem to me to rise that level. I am going to give an accomplice instruction, let the jury decide whether they wish to find that Miss C is an accomplice. But I think it would be just as well argued that she's not. And of course, if it, as you rightly state, an accomplice's testimony has to be corroborated. But it says here, if you find that the witness was not an accomplice, then you would judge the weight to be given their testimony just as any other witness. So if they find she's not an accomplice, then I can't say under the facts I heard whether I would give an instruction telling them that she is in fact an accomplice based upon the facts I heard. She did try to, I mean, her credibility as a witness, of course, has come into question, and that's where the recording comes in. It's not clear to me, I must have missed it, why she decided to lie for her. If the jury wants to believe that version. I also have Mr. Dox's testimony about the pistol, about the live rounds, and I thought I heard someone talk about a lot of money.
Mr. Dodson never identified Ms. Isaac in court.
Well, you identified a photograph. And for the record, Ms. Isaac has totally changed from that photograph. She has glasses on. I don't know if she actually wears glasses or not. But she has glasses on. She doesn't look anything like she does in the photo. So I can see how they can do that, but she has been identified through the photo, also through Ms. Isaac. So just because Mr. Dodson, and it was the other fellow that didn't even look at her. I thought it was rather odd. He walked all the way around and he kind of looked out in space out there, but he never looked at her. So I don't put a lot of weight in that. I will note that, in my opinion, she doesn't look at all like the photograph. So I can see how that can happen, but it doesn't mean he identified her in the photograph, and the photograph has been identified as being Miss Isaac. So I can see now. Who was it that said something about it? Was it Mr. Dodson that said about a wad of money?
Mr. Dodson's testimony was that she had a wad of money in her back pocket.
And so, now, what also it seems rather odd, I mean, we had people looking out the window and then leaving the window to go to another vantage point or something like that, or leave the window to go move a plate or something that had food on it. I don't know why they decided to do that at that point, unless they had a dog they didn't want to eat their food. I didn't catch that, but they left, and so what was confusing, troubling, I think, there was some different colored pants that were described as the female, one female, the deceased, having gray slacks, and another female with some sort of multicolored. And one of the witnesses talked about how a female crawled through the window or something like that to get into the car.
That's Ms. Kay. I mean, Ms. Thomas. Judge, that's not perfect.
Pardon?
That's not entirely clear, however, because they're described someone wearing colored leggings, and we know
So-
that it wouldn't take.
So I guess the jury can be justified saying, well, look, that someone missed something, because it doesn't make sense for someone who's just been shot to rifle through the car. So, which would circumstantially say that doesn't make any sense that the person that was shot would rifle through the car and look for something.
But Your Honor,
So I'm just saying that's circumstantially, that would mean that there was another woman there that did that. Because it just doesn't make sense that someone shot and they're going to take the time, and they obviously took off trying to get help and ended up at someone's house. That they would take the time and rifle through to look for something doesn't make any sense. So, I mean, circumstantially, and also going along with what Ms. C had to say. obviously, the jury could make the conclusion that she's telling the truth, that Miss C did the shooting, and in fact, she was the one who was rifling through the car. And then the fact that she disappeared for a while, and she lives 100 yards away. All that the jury could take into consideration. So the fact that Miss C tried to cover for her and also came back and got her, I don't know if that rises to the level of accomplice. I don't know if an accessory after the fact is by definition an accomplice. Maybe they are, if y'all want to look into that. But, so we have a murder and perpetration of a felony. We have 3 counts of murder, 1 being murder first degree. So I think the jury would be justified in returning the verdict for all 3, for the male, the female, and the fetus, based upon the facts I've seen. And I guess, like everyone has rightly pointed out, it all boils down to the testimony of Miss C, which is corroborated by the fingerprint. And it can be argued away that perhaps she might have touched it, but I think the state has carried the burden of proof, at least to overrule a motion for judgment of acquittal. So, motion is denied. Now, what do y'all want to do? Y'all want to continue, or y'all want to start back at like 8?
Whatever your honor says, whatever time you want to start back in the morning, we certainly need the opportunity to review what's going on with our client before we want
They don't let me forget
6 o'clock and do that. That's,
6 o'clock.
I don't think we're going to be that
No.
push for time tomorrow.
I'll be lucky to be here at 6.
If we have to come at 6, I want everybody here
I'm
at 6.
fine with starting earlier, if we all get here. So, just so we
I have
can.
2 kids that I have to get off to school.
I see. I understand. Okay, well, then let's start straight at 9 o'clock. Now, the jury charges, of course, the defense is it wasn't none of us. So I have murder first, murder second, voluntary manslaughter. Under the circumstances, I don't see how if they were to believe that if they were to convict, I don't see how it could be a reckless homicide.
Your Honor, we would request all of the lessers.
Well, I know you would, but I don't see.
We are requesting all of the lessers, let me be more clear.
Yeah, I know, but if you, I don't see the logic. And number 2, I don't see any proof that it's a reckless homicide or a negligent homicide. When someone shoots, or whoever you say it was, shoots 6 times into a car, how that could be a negligent homicide or a reckless homicide. So
Your Honor, in the shots through the doors, I think it shows that on the green Honda, and I don't know, but those shots could have been the ones that went into it. And you can't hardly say that they were aiming with premeditation, whoever did the shooting, to kill you. So it could be that they acted recklessly, knowing that there's a risk of that he would die, but doing it anyway. That's a jury question. So that's the reason that they always tell the judges to give all these lesser included.
So I guess the argument will be, if you believe she did it, it was reckless. I don't get it. I don't see it. And I'll consider it, I suppose, but right now I just have murder second degree involuntary. And I don't see how a jury can return a verdict to reckless homicide. Now, if there was proof that they shot the gun in the air and it ricocheted off the light pole and came down and hit someone in the top of the head, then perhaps reckless homicide.
That's a jury question. It just is.
Well,
That's the reason we have to.
I saw no proof in the record that this is referenced, so. Or
Saw no proof
negligence.
in the record of voluntary manslaughter. But, there's no heat of passion here showing. But we give those instructions always because it's up to a jury to decide whether they want to decide, to reach a verdict.
Well, they have to get by murder first, too.
That's
And
true.
if they find that she's not guilty of that, then they're not gonna find her guilty of anything lesser. So, I'll think about it. But anyway, we'll talk about it at 9 o'clock in the morning. So you anticipate calling witnesses?
We're gonna call somebody that aren't this thing long.
Okay. Well, why don't
You want us to be ready to argue?
I email you what I've got so far? I don't think my secretary's made any changes that we talked about. But I can, anyone have y'all have my work email?
I did not. Now, Rich,
Yes, ma'am. I won't bother giving you Dad a copy of that. Do you do email yet? Oh, you did? All right.
It won't work up here.
Oh, I know. Well, I won't work up
It
here.
works for the government person, yeah, but it won't work.
Personal. Yeah, it's, and y'all have my work email? Okay. So anyway, what we can do is, I will email a copy to myself, and I'll get everyone on if y'all just swap emails, and we can all get on a common email, and then I'll send you what I have. I'll probably stay here and work on it for a while, so we can have it as some kind of.
And there's one other matter that I'd like to take up with the court, and I don't think I've been able to work anything else to state on it. Yeah. Despite the numerous stipulations we've done up there. Come on now, we have.
Well, I agree.
We really have. We
Yeah, I'm
have.
glad, because we'll be here till.
There are signs up over the telephones in the jail that say, and they know this, there's signs up there that say, this call is being recorded. You're being recorded on this, so that she would, under that phone she's talking on, is going to be a big sign saying, you're being recorded, Miss
Oh,
Susan."
yeah, I agree.
And I want to be able to take a picture of that, or have a picture taken of. And I can't get in to do it without a court order authorizing it. I called up here now, Your Honor, authorized me to go into jail where they make those calls, take a picture, and if I need to subpoena a witness from jail east down here, I'll do that. I would hope that's not necessary, but it may be.
A witness wouldn't be necessary anyway. My concern with it is he's wanting to enter into evidence of stipulation that has to do with a prior consistent statement that was marked for ID purposes only, when the only reason is to have a picture of what the thing says anyway.
Right.
It's on the recording itself that you're being
Yeah.
monitored.
You know,
I just don't see the logic in putting
How do they know you even hear that? That the defendant even hears that? They don't know. Do you know that the defendant hears that? How many defendants do you talk to, Mr. Bennett?
They know, I talk to
Well, I mean, with the same token, how do you know the defendant sees the sign? You don't know what the defendant sees.
That's
I
exactly
don't know
right.
how the defendant can read. I mean, you know, come on. So, no, I don't think it's, you know,
I just don't
known
know
about this,
something
known about this
about
recording for a long time, right? When did y'all find out about this recording? Y'all had obviously enough time to transcribe it.
No,
We
we
could have
had
talked
it
it down and
transcribed.
say about it, but they didn't do it then. They did it when they put evidence up I couldn't cross-examine or ask about it.
And we did it consistent with Tennessee case law.
Right.
Right.
we knew that they intended to enter that jail phone call yesterday.
Okay, so I mean, you could have asked for a, you know, this lady, how are you gonna get in there before you get back here by 9
I'll go
o'clock?
back tonight, I'll go by there tonight if Your Honor, give me the order.
I'm not gonna do that, it's just too late now, I'm not gonna do that.
What about tomorrow, man?
It's on the audio recording. So, it's already there. Like
No
you say, you
objection.
could have done that a while back. You did it.
You had no idea they would do that.
Well, you should have, if you had the time to transcribe the thing then you had time to go buy your photographs. But I'm not gonna,
It's on Saturday.
And I got the jail tapes on Saturday.
Saturday. Is that this Saturday?
This Saturday.
Is that this Saturday before we start trial on Monday?
6 calls.
Yes. Yes.
Calls.
Your Honor. Go. Yeah, I know. That's what I say
okay,
too.
so
No, I'm sorry, let me
how
break that, it wasn't
is
Saturday.
this gonna get out to the penal one? Or
It
really?
wasn't Saturday.
How's
I'm
it
sorry.
get
I
out?
know how to do it. You go out there the fastest way is to
I
go
don't-
out and
I don't wanna
drive
be
around there
wrong
with
with
your cell phone, email
Yeah,
it
is
to
that our,
myself. And we'll
I believe it was just me.
So how
It's
are we
Thursday.
gonna?
Thursday.
I think the state is correct. I mean, it's already on audio, and you know, I don't know. I don't know if your client's planning on testifying or not. We haven't gone through that. But, so are you gonna testify to it?
what I do is I'll get a subpoena laid on the person out there tonight. We'll just bring the person in here
If your honor orders,
and let them testify.
if your honor orders, they can come in as substantive evidence. We're not disputing that it's there. I just don't, the state doesn't think it's proper to put in as substantive evidence.
It hurts their case. That's why they don't want it in. It hurts their case, but it's true.
I finished my argument.
But it's true. Yeah, that's what it is.
Are you done?
Yeah.
Okay. Now, like I was saying, for the third time, I don't think it's proper to put in as substantive evidence something that tries to rebut something that's in trial purposes only, especially when that piece of evidence says it anyway.
I agree.
Good night.
So,